Welcome, everyone. Thank you for joining us for the launch of Hate Speech and the European Court of Human Rights. My name is Holly Johnson, and I serve as the Associate Director of Columbia Global Freedom of Expression. If you're not yet familiar with our organization, we work to advance international standards on freedom of expression and access to information. Our flagship database includes more than 2,500 analyses of landmark court decisions from more than 130 countries. It's updated weekly to reflect the evolving jurisprudence globally. And I encourage you all to explore it, and please sign up for our newsletter to stay connected. We're really grateful to Wright Tremaine for hosting us today, and to the author, Natalie Alkiviadou, for coming to New York. Natalie, in her role as Senior Research Fellow at the Future of Free Speech, which is an independent, nonpartisan think tank that's located at Vanderbilt University, has been a valued partner with global freedom of expression for many, many years. And we're especially pleased to host this event to celebrate and discuss her important new book. Many of you may recall that back in 2023, she authored a special collection paper for our initiative. And that paper mapped trends and practices across regional and international institutions and their approaches to hate speech. The work drew extensively from our database and the database of Future of Free Speech, and it's informed the book and the conversation that we'll have today. In her new book, Natalie takes a deep dive into the European Court of Human Rights jurisprudence on hate speech, demonstrating how the court has applied inconsistent standards to different forms of expression, sometimes leaving gaps in protection and creating uncertainty for both states and individuals. She situates this analysis in today's urgent context: the regulation of online speech by governments, the Council of Europe, private platforms, and the broader risks these dynamics pose to freedom of expression across Europe. Hate speech, sadly, is not only a European issue, as we know. It is making headlines around the world, while developments in the United States are reshaping platform policies and influencing global debates. Because this is truly an international problem, one that courts, regulators, and technology companies alike are struggling to address, we thought it valuable to bring a comparative perspective to the conversation. And we're really honored today to have a truly distinguished panel with us. Joining us is R.A. Nair, President Emeritus of the Open Society Foundation and former Executive Director both of Human Rights Watch and the American Civil Liberties Union. Few figures have shaped the modern human rights movement as profoundly as R.A. His classic book, Defending My Enemy, which chronicles the ACLU's decision to defend the rights of neo-Nazis to march in Skokie, Illinois in 1977, has just been republished, and it includes new chapters by R.A., Eleanor Holmes Norton, and Nadine Strossen, highlighting the book's relevance today. We're deeply privileged to have him with us. We're equally fortunate to be joined by Mishi Chowdhury, a pioneering technology lawyer on civil liberties and a civil liberties advocate with practices in both New York and New Delhi. She is also the founder of Software Freedom Law Center, which is India's leading nonprofit dedicated to defending digital rights. Under her leadership, SFLC received the Electronic Frontier Foundation's Award for Defending Digital Freedoms. It's one of the most prestigious awards recognizing leaders and organizations advancing innovation and free speech online. Mishi brings invaluable expertise on how hate speech intersects with technology, regulation, and online freedoms. I do, however, have some unfortunate news to share. Richard Wilson informed us this morning that he is unfortunately unable to join us today due to a family medical emergency. And then Rob Balin, a leading defender of media rights in the United States and internationally, was scheduled to moderate today, but also sends his regrets due to an unavoidable conflict. So I will do my best, humbly, to step in today as moderator, and I thank you all very much for your understanding. Before we begin, I'd also like to extend a very special thanks to Sandy Colliver, who helped make this event possible. We couldn't have done it without her. And again to Rob Balin and Wright Tremaine for hosting us this afternoon. So today's program is also being recorded. We're going to have an edited version posted online in the coming weeks. So now we can get started. Natalie. So you've been a scholar of hate speech jurisprudence for many, many years. And through your work with the Future of Free Speech, you developed a database on hate speech related cases, not only from the European Court, but also from the United Nations. And you've also co-authored a handbook on hate speech laws. What is your main objective in publishing this book at this moment in time? And what gaps in scholarship and policy do you aim to address?
Okay, well, thanks very much for hosting the event. Thank you to the speakers for coming and for everybody here today. It's really wonderful for me to be here. I'm also a little bit nervous, and thank you, Hawley, for always helping me and supporting me. Why now? I think that the European Court of Human Rights is in a little bit of a odd situation when it comes to hate speech jurisprudence. We are seeing a systematic lowering of the protection of freedom of expression. We are increasingly seeing a situation whereby the European Court of Human Rights is imposing a positive obligation on states to legislate on hate speech. And we're seeing all this within a framework that has no kind of analysis within the framework of, I don't know, social science, research. So the court is systematically delivering opinions on hate speech without really backing those up. And I'm simply concerned about what that's saying to Council of Europe member states when it comes to the freedom of expression. Because let's not forget that this court is covering a region of countries from Germany to France to Armenia. You know, it's quite a large region in Europe. And I feel that I'd like to give something for scholars, for policymakers, for the court itself, to really think about, are we on the right path when it comes to how we're dealing with hate speech in Europe? I feel that we're not. And I really wanted to dig really deeply into the jurisprudence on hate speech, because we do see it analyzed in some books or in papers and in policy papers, but I wanted to bring all that together. And I feel that now is a really important time also because of what's going on with a lot of these hate speech laws in Europe. So I just basically wanted to bring all those cases together and analyze them. And your database and our database have really helped me kind of collecting all this together. And as well as assessing the jurisprudence at a European Court of Human Rights level, I also wanted to kind of open up the discussion on other frameworks that can be used to deal with hate speech, whether that's counter speech and, you know, other methods that I've kind of looked at in the book. So that's basically the reason.
That's fabulous. So let's dig into some of like the specific issues. Mm-hmm. One of the ones that you discuss in depth in the book is the use of Article 17 by the court within the framework of hate speech. Could you give us some recent examples to illustrate the problems of that approach?
Yeah, so Article 17 of the European Convention on Human Rights essentially prohibits the abuse of convention rights for the enjoyment of other rights. So I cannot abuse my right to freedom of expression and abuse somebody else's rights. And this was developed post-World War II and used in older cases against the German Communist Party and, you know, and within that kind of framework. And if you see in the discussions for the creation of the European Convention on Human Rights, that article was really reserved for those groups or persons which sought to destroy democracy. That was the kind of idea behind Article 17. It's the embodiment of militant democracy within the European Convention on Human Rights. And we've seen it used a little bit over broadly, I would say. I'll give you an example of a Greek case, the case of Lenis versus Greece. It's a case a couple of years ago. It was a person who was somebody in the Greek Orthodox Church. Was he a bishop or I'm not sure of the different rankings. I can't remember exactly what his ranking was. And he had made some comments on a politician who was supporting civil partnerships. At the time, it was a discussion about civil partnerships in Greece. And he had made some comments, spit on them about politicians who support civil partnerships, and different other slang words about the politicians, but also about members of the LGBT community. He got into trouble, but the interesting thing about that case was that the newspapers and the media and the kind of discussion online was like, what is he saying? This is ridiculous. And there was a lot of counter speech, which was actually very empowering for the community itself in terms of the discussion around civil partnerships, because they were reacting to him and how awful his behavior and his words were. His words, actually. And he got into trouble nevertheless, and he took his case to the European Court of Human Rights. And the European Court of Human Rights said that this was such a serious case of hate speech that they should apply Article 17. And when you apply Article 17, it kind of reduces the legal analysis of the expression in question, because it's kind of, it kicks the case out. So it doesn't have, that very detailed Article 10 analysis, with Article 10 being the right to freedom of expression. I just know that, the audience is international, so I'm just making a few, clarifications when I'm referring to the articles. So there was a bit of a Article 10 discussion, but they also included Article 17. And I think that is slightly dangerous, because that's not what the European Convention on Human Rights or the drafters of that convention were after when they were drafting Article 17. That was reserved for, very, very, very destructive voices. And using it against somebody from the Greek Orthodox Church, I mean, what did anyone expect that person to think? And then you come into the discussion of, his beliefs within the framework of Article 9 and religious beliefs, but then we do go to the fact that he was very offensive. He was extremely offensive. But the thing is that the fact that he was offensive and the use of such a strong article such as Article 17 within the ambit of an article as important as the right to freedom of expression, that kind of combination is a little bit daunting to me. And I really preferred when it was the media in Greece. I mean, I was watching it before it even went to the court, and how they were kind of counter-speaking. And that counter-speech itself was very, very empowering to the community. And then you had his speech shut down. You had the European Court of Human Rights coming and saying, this is so awful that we need to use Article 17. And then when that did happen, we had the reaction by homophobic people saying, look, the European Court of Human Rights is silencing the opinion of, this priest. So we can see this kind of confusion, and I'll stop there. But does that make
that's super helpful. And I wanted to kind of tease out a little bit more on this Article 17, because one of the other concerns that you raise in the book is this inconsistent application of certain standards and principles. Mm-hmm. And one of the ones that you talk a lot about in Article 17 are the denial of the genocide. And I was wondering if you could maybe give an example of one of those cases and some of the problems that have come out of that, the dual use of it.
Right, yeah, that is a very, very important point. Article 17 has been mostly reserved when it comes to speech to the denial of the Holocaust. And again, I mean, it's really important that we look at the backdrop of the Council of Europe. It was born from the ashes of World War II. The trauma that exists and that is, that cannot be disregarded when it comes even to the infrastructure of the Council of Europe itself. And when I am critical of the court, I'm still understanding, of the big fear that has been created and exists in Europe when it comes to speech. I mean, that's nothing that we can ignore. I can sit here comfortably being very critical of how the court is behaving, but it's also very important to look at our history as a region and the history of the Council of Europe. So I really want to underline that. That doesn't justify the way that the court is treating expression today, but I think it's nice to kind of discuss openly about, you know, the background as well. And one of the kind of results of that is the use of Article 17, sorry. So again, that prohibition of abuse of rights when it comes to denial of the Holocaust, which is not allowed. It's so much not allowed that we don't really have the use of Article 10 when it comes to Holocaust denial. So that kind of full legal test under the right to freedom of expression. Towards more recent years, we've had a mix of Article 17 and Article 10, but really I won't get into too much technicality, but it's it still kind of kicks out the cases without proper assessment. The problem, though, comes to, and I'll give there's a case of it's Wright versus Germany, whereby it was a private letter sent to an academic saying, "I don't agree with you," and it was something about Hitler and the number of gas chambers, he had sent it in a private letter to a scholar, and the scholar took that letter to the police. This is in Germany, where, you know, we have the most kind of aggressive militant democracy because of the history of Germany. And he got into trouble, and we're talking about speech in a private letter, and that was for denial of the Holocaust. But so I'm giving that example and comparing it to the case of Perinçek. It's a Turkish case where somebody in Switzerland, he was in Switzerland at the time making a speech and discussing the Armenian genocide and saying basically, again, you know, it was within the framework of denialism and of that genocide. And he got in trouble in Switzerland, and he took the case to the Europe. And when I say trouble, by the way, I'm using that very general term because the cases in my book, they're all criminal law cases. And I think that's very, very important. You know, it's the imposition of criminal penalties. Anyhow, so he had got into trouble in Switzerland, and he went to the European Court of Human Rights, and he's like, well, it's my right to free speech. And there we see a case. I mean, I recommend that case to anyone because it's one of the most detailed cases that has been issued by the European Court of Human Rights within the ambit of freedom of expression. There's really an analysis. And the court's like, well, he said that in Switzerland, and, you know, the genocide we're talking about a long, long time ago, and he wasn't, you know, no one was going to get hurt by that. And, you know, there's no agreement on whether that genocide happened. So we have a court constructing the historical memory of a people. I really don't think that that's its role. You know, for the Armenian people, that genocide is very real. And it's not for the court to come and say if it is or not, or if people across the world agree whether it happened or not. And with that case, it was so detailed in protecting expression. And if you take that and you compare it to the way it treats the Holocaust and denial of the Holocaust, that it's just such a big imbalance. But I think that we should not be coming to a discussion when we're comparing atrocities and you know, within a judicial framework, there is no doubt that of these atrocities, and any reasonable person would not doubt these atrocities, but this is not what freedom of expression is about, right? So I think that's when the court actually becomes almost activist in kind of constructing memories, and for me that's slightly problematic. And I was actually having a chat with my friend last night about, I mean, I'm from Cyprus, and she's also from Cyprus. We studied together, and we're like, Cyprus is such a small place that many people don't know, you know, what happened, and that we're divided, and, you know, this war has tormented us, and this is very related to Article 17, by the way. And for us as a younger generation that didn't live the war, well, not so much younger, but we didn't go through the war, it's still very much part of our identity. Having a court coming and saying, oh, that didn't happen, is really not what we want. I think that's basically within, you know, when in relation to your question.
Thank you. So we're also seeing the court using other articles to address hate speech. Namely, I'd like to ask you about its use of Article 8, which many of us know is sort of the right to privacy, and then also Article 14, which is the right not to be discriminated against. And there's a particular case, Minassian v. Armenia, where the court relied on both of these articles to extend protections to human rights defenders. And it was for their work actually by association. They were defending others. And these cases ended up putting positive obligations on states to proactively regulate hate speech. And I was wondering if you could give a little bit of detail on those cases and explain this conflict.
Yeah, definitely. So Article 8 has been used in hate speech legislation, hate speech jurisprudence. It started off actually with a case against Turkey. It was a case, Aksu versus versus Turkey. There's so many different names that I get slightly confused in the pronunciation. I apologize. Anyway, and it was about alleged hate speech against the Roma community. And in that case, the court said, yeah, this could be discriminatory, but for one reason or the other, it said that the publication was academic, that was allegedly, Romophobic, that they decided that this wasn't a violation of Article 8. But then after that case kind of set the scene for, speech might be discriminatory, and the victim of hate speech can bring a case under Article 8. And that slowly developed into a situation whereby today, I won't go through all the cases, but whereby today a state can get in trouble, A, for not investigating a hate speech case, an alleged hate speech case, or for not having proper legislation in place for hate speech. And that comes within the framework of positive obligations, that a state has a positive obligation to protect potential victims of hate speech from hate speech. And also in the recent Armenian case, and in an even more recent Bulgarian case, but that is rather complicated, and let's stick to the Armenian one for now, because I want to give everyone else time. But the thing is that the court is coming and saying, even if you're not the target of hate speech, so you're defending, so in the Armenian case, it was activists defending the LGBTQ plus community. And in that case, the court was like, if you're a victim of hate speech because you protect a community, then you're a victim of hate speech by association. So you're not the direct target. I'm not a target because I'm lesbian. I'm a target because I'm protecting the LGBTQ plus community. You can also, the state also has to protect you. So we have a situation, basically, to sum up, whereby the court is coming and saying the state must have legislation in place for victims of hate speech. So there's a positive obligation there. So that's quite a stress, on these states of what they have to develop. And those who support potential victims. So it has broadened the scope. And then where does this end? And the kind of, to bring all the points that we've kind of discussed together with our Article 8. Article 17 being used kind of in a very relaxed manner, even when it comes to like the case of Lenis versus Greece. Article 10 being used for hate speech, which is merely offensive. And then Article 8 increasing this scope that states have when it comes to, legislating against hate speech, even when that hate speech is not targeted to the victim itself. Plus, we have a situation where the court has come and said, even if you're not the speaker of hate speech, so the case of Sanchez versus France, which I discuss in the book, even if you're not the speaker, so Sanchez was a politician, and there was a comment under one of his posts that was hate speech, or France and the court considered it to be hate speech. And he got in trouble for that, even though he was not the author or the speaker. So putting all these 4 or 5 points together, what is the court actually telling states to do? I'm not really sure. It's very broad.
Well, this has been a great foundation of
Okay.
some of the primary arguments, and so now maybe we could open it up a little bit. Nishi, I see, do you have a question now, or no? No? Okay.
No.
Okay.
I'm just fascinated. So
Great, okay.
I'll ask later.
Okay,
Please.
wonderful. Well, I thought now we would move on to REA, and we definitely want to speak with you about some of the findings of the republication of your book. But before we start, would you like to address any comments to?
Well,
Natalie?
the one comment that I would make is that reading your book, and I enjoyed reading the book, it does seem to me that the way in which we deal with hate speech in the United States seems relatively sensible. That is, essentially, it seems to me, we don't have legislative prohibitions on hate speech per se. We consider it, like other speech, not subject to punishment per se. But there are certain circumstances in which there are harms associated with hate speech. And when such harms can be proven, then we can punish those who engage in the hate speech, so that when there are what the courts call true threats, which cause people fear, you can punish hate speech or prohibit hate speech. When there is targeted harassment, you can punish or prohibit hate speech. We have the Chaplinsky case. I don't think it's been followed very much, but in that case, there was a sudden confrontation and the use of fighting words in the context of that sudden confrontation was something that was subject to punishment. And then the most significant form of punishment or prohibition is if there is incitement of unlawful action, and the incitement takes place in circumstances in which such unlawful action is likely. In those circumstances, there are legal measures that can be taken against hate speech. That is the most important case we have in the field of hate speech. That was the Brandenburg versus Ohio case in 1969. And essentially, it's been an immense protection for speech, because many circumstances in which there might be incitement to violence take place in circumstances where there is no imminent likelihood of the violence, and therefore it serves as a great protection for freedom of speech. So I came away from your book feeling relatively good about the situation in the United States.
Well, thank you. That was a great segue into a discussion of your republication of your book. So you've written about one of the most important hate speech cases in the United States. The re-release of your book, Defending My Enemy, could not have come at a more important time. Your main arguments resonate today as much as they did then. And so I have sort of a two-part question, and drawing on the standards that you've just explained to us. In your chapter 10, you discuss some events from recent decades since its first publication that have shaped your thinking about freedom of speech. One of them was Charlottesville. So I was wondering if you could take a moment to summarize for those of us or those people here who have not had a chance to read your book, so what your main arguments were in the book, and then how Charlottesville and those protests changed your thinking on thresholds of violence.
Well, the Charlottesville case, I think, is relatively well known. In 2017, there was this demonstration. It was triggered by the removal of a statue of Robert E. Lee in Charlottesville, Virginia, and a group organized or proposed a demonstration, a Unite the Right demonstration. And they went, when they were turned down for a permit for the demonstration, they went to the Virginia ACLU, and the Virginia ACLU litigated in their behalf and won them the permit. Then, when the demonstration took place, the demonstrators who had told the Virginia ACLU that they were going to engage in a peaceful march came well armed. They came armed with sticks, with knives, even with guns. They carried lighted torches, and one of the demonstrators drove a car into a crowd, killed a woman, and injured a number of other people. And following that demonstration, the ACLU revised its policy with respect to demonstrations and said that it would not represent groups that came to demonstrations with weapons, that weapons serve a coercive purpose. They suggest a readiness to engage in violence, that the ACLU defends freedom of speech for purposes of persuasion and not for purposes of coercion, and would not represent such groups subsequently. And I endorse that position. I never confronted precisely that issue during my tenure at the ACLU a long time ago, but it does seem to me that it is appropriate to limit one's defense of freedom of speech to circumstances of persuasion rather than coercion.
Excellent. I'd like to ask you now about some recent developments in the United States that have creating some new challenges for us. Since the assassination of Charlie Kirk, hate speech in the United States has been all over the news. The Attorney General of the U.S., Pam Bondi, said in the aftermath that the U.S. government should go after citizens found engaging in hate speech, seeming to disregard constitutional protections. Teachers, professors, and other people who have made online posts regarding his assassination have been fired and removed from their positions. Some of those cases will certainly make their way to the U.S. courts. But this situation really raises some very serious concerns, not only about the U.S. government's understanding of constitutional protections, but the court's ability to enforce the Constitution protections and the chilling effect, ultimately, that these types of things will have on public discourse. So I was wondering if you could maybe talk to these sort of concerns and what sort of assaults you're seeing on our well-established standards.
Well, look, I think we're in a situation where we have more significant assaults on freedom of speech today than perhaps at any time previously. There have been a number of bad periods in American history. If you think of the 20th century, one thinks of the World War I period in which speaking out against American entry into the war or against the draft was punished under the Espionage Act, and then the amendments to the Espionage Act, which were in the 1918 Sedition Act, and the state equivalents of those, and the leading scholar of free speech of that period, Zechariah Chafee, counted close to 2,000 prosecutions for speech in the United States during that period. And, the punishments were very harsh. So, Eugene Victor Debs was sentenced to 10 years in prison, and for a relatively mild statement. He was eventually pardoned, or his sentence was commuted by Warren Harding in Christmas 1921. We don't necessarily think of Warren Harding as a great defender of freedom of speech, but he and Calvin Coolidge commuted the sentences of a large number of people who were convicted of speech in the World War I period. We had the post-World War I period of the Palmer raids, responding to the Red Scare of that period and the anarchist bombings of that period. They never actually identified anybody who was responsible for the anarchist bombings, but there were a lot of people imprisoned, a lot of people deported. We had the post-World War II Red Scare, the congressional investigations, loyalty oaths, purges from government office. We had the Vietnam War period, in which literally hundreds of thousands of people were arrested in demonstrations during the Vietnam War period, and people were imprisoned for things like draft card burning. A lot of people were imprisoned because they were denied conscientious objector status. And we had a very high level of political surveillance during that period. Political surveillance, sometimes which had been underway for many, many years, but came to the fore during that period. The difference between, I think, what is going on today and what went on in those earlier periods in American history is that a lot of the attacks on freedom of speech in the current period have involved establishment institutions, elite universities, major law firms, broadcast media, and now looks as though the foundations are going to be next in line. Trump and Vance have talked about the Open Society Foundations and the Ford Foundation, and that would have a significant impact on the civil society organizations that receive support from such foundations. At least as far as the elite universities and the major law firms, and to some extent the broadcast media, the majority have paid up when Trump has attacked them. In the case of the law firms, the attacks seem to have been based on personal grievances that Trump had against the law firms. So the attack on the Paul Weiss firm here in New York was because a lawyer from that firm took a leave of absence to work with the Manhattan DA's office on an investigation of corruption within Trump's business. And Paul Weiss, which could easily have vindicated itself in court, and Trump's executive order dealing with them even prohibited or purported to prohibit their personnel from entering federal buildings. Paul Weiss agreed to perform, $40 million worth of pro bono work for Trump-supported causes. And if you take altogether what the different major law firms have agreed to provide in support for Trump-supported pro bono work, it probably amounts to about $1 billion worth of assistance. And probably another impact of that is that such firms will be deterred from providing pro bono assistance to many of the groups for which they have previously provided such assistance. So I think that's a quite different sort of assault on freedom of expression than we've seen at any time previously. And I think the worst part of it is the degree to which establishment institutions, which have substantial financial interests at stake, have capitulated to the administration.
Thank you, Ari. It's very depressing but accurate account of what's going on here. And I'd like to extend the conversation now to India. I think there's some interesting comparative perspectives to be drawn from there.
And Holly,
Yeah.
before we go to
Sure.
India, could I just turn to introduce Victor Kovner, a senior partner with Davis, Wright, Tremaine,
Thank you for coming.
and a longtime defender of media rights, freedom of expression. We're honored and thrilled that you're here with us. And I wonder, I know that you have to leave early. I wonder if you have any questions you might want to pose or comments.
And I have a couple of comments. First of all, welcome to Davis Wright. I'm delighted that you're here about this subject, and it's great to see REA. Of course, this firm does a lot of First Amendment work, and we are adverse to Trump and his progeny in a great many circumstances because we represent the press, and they're suing the press all the time, and we do a lot of that work. But interestingly enough, they've not come after us yet, because they sort of understand that when they sue people, people they're suing have to have lawyers, and that's their obligation to defend them. And the people they've gone after are people who have been adverse to them politically, directly. Oh, that's been the principal drive, and that they use the phony, distorted, misleading charge of anti-Semitism to justify their attacks. I looked at we followed, we know these law firms, some of whom have settled, some of whom have not. Those who have not have gone to court and won. He hasn't won any cases against law firms. Those who have settled have found that once they enter into a settlement, of course, they want war. I read the original Paul Weiss agreement. I haven't read the other ones. And the $40 million to which RAA referred obligated Paul Weiss to spend $40 million of pro bono time. They already spent $40 million a year of pro bono time on fighting anti-Semitism and on veterans' causes. Did not say Trump causes. And it was clearly, fairly, and Trump's lawyers, have negotiated that agreement. And if you looked at that agreement and read it, some of the times when this office is fighting anti-Semitism, as we define it, and as I think most of the public define, Paul Weiss could come and help us, and it would count toward what they agreed to do, the way it is written. But of course, the firms that have settled and universities that have succumbed find that once you make a deal with them, they come back and want war, and almost to settle is to invite further intrusions. So I did want to make that comment. The other thing is, of course, we've always, First Amendment Council, we've always presumed, and in lots of cases, ARIA cited some, that hate speech is constitutionally protected. There are narrow exceptions. ARIA has listed some. Speech can still be actionable. It can be actionable in fraud and intimidation. Threats there tend to be narrow, but things that are purely hate speech. Jews shall not replace us was the chant in Charlottesville. That's protected speech, appalling as it is. And it's so interesting to hear the human rights judiciary looking at matters differently as EU confronts it. Of course, there are great traditions Europe that have barred certain kinds of speech, as Germany most particularly has, and the United States doesn't necessarily have the best standard. But in a time of hate speech, and the other irony, I can't stop called upon me, speaking more than I should. The other irony is, of course, that Trump and his disciples say they are committed to free speech, and they're out to defend free speech because they're complaining that under the Biden administration, the large platforms in online media had imposed guardrails against hate speech, which they loathed and successfully beaten back, not in law, but just by the power of their political force and money. But of course, when you examine their claims to defending hate speech, it turns out that what they're defending is their speech, and not speech that they don't like. They have not yet absorbed the notion that to defend hate speech and to defend free expression generally it includes the obligation to defend speech that you loathe. That's tough for people to observe. And for the Attorney General of the United States, Ms. Bondi, a so-called attorney, to say that it's time for the government to go after hate speech, oblivious to the notion that there are all these Supreme Court cases that say it's constitutionally protected. I'm sure she just doesn't know it at all. So I'll stop and say it is, Sandy, as usual, you are being commended to convene a group to discuss these critical questions of expression in the context of hate speech.
Absolutely. And Victor, could you just tell us a little bit about Davis Wright Tremaine's practice in this area?
Well, we defend institutions that are sued by Trump, by Dershowitz, by Michael Flynn and his family, by Nunez, one of the key Trump operatives, and others, with great frequency. And we're very successful. And the sad part, of course, can't go without saying that this firm was counsel to CBS on the 60-minute case, which is a nonsense, bullshit case, use a legal term. And yet it was settled painfully because CBS was owned by Paramount and had a pending merger. And as soon as it was settled, within days, the FCC approved the merger. I mean, it was extortion. It was, let's say, a form of extortion, if not legal extortion. And then there was the Stephanopoulos case, on the definition of rape as he used the judge's definition, and described to Trump, again, a case that would have been won without question. And ABC, not ABC News, but its owners, Disney, who had several years of costly, difficult challenges by the right, decided to settle that, even though there was no question that we were going to win it. The one small mitigating factor in the CBS case is that two unrelated individuals, upon reading of the settlement of the CBS 60 Minutes case, where the claim was that CBS had in a distorted manner, edited its interview of Kamala Harris in a misleading manner, which was bullshit. It was nonsense. No basis for it. But CBS had paid, I want to say this for CBS, they paid an amount of money which was the defense costs they would have incurred.
60 million, right?
No, 15 million, if it had been tried and appeals had been taken to the Supreme Court. And beyond that, they would not go, which puts it into, as they characterize it, into a nuisance settlement. Let me say that was very, but two people saw that and said, I too was misled by the editing of the Kamala Harris, and I too will now want to, and have brought suit against CBS. Those cases are pending. We're delighted because we're handling those cases as well, even under CBS's new management. And we will win them and prove that there was no basis to the original claims.
Yes, thank you for that. When we wait for those cases, we want to put those decisions in the database. That would be awesome. And thank you very much for this insider perspective on what's been going on. And with that, I guess we'll turn to Mish now and get a sort of sense of what's going on in India and hate speech standards. You know, there's no regional court for Southeast Asia, but India is a Commonwealth country, and I love reading their decisions because they very often will cite American jurisprudence and international jurisprudence. Could you give us a sense of the definitional frameworks that India relies on and their thresholds of harm?
Sure. Thank you for hosting this. Before I jump into it, I do want to say my day job is as a U.S. General Counsel. There are a big network of general counsels who are making note of which firms are on what side. TWT we kept in the roster because we were like, okay, we are going to continue to work with them. And that gets noted in the commercial aspect as well, who's doing what. So that does make a difference. Thank you. Natalie, this book, I'm so glad that at this point in time we are having that discussion. Obviously, we're in such august company. In terms of what US stands for, but I read it with great interest because I have a lot of disagreements with many things in Europe, and when I can get my hands around some meat of the matter in such important discussions, that really helps. I think for a long time in the world, the aspiration was First Amendment, and then Europe was, okay, even in online stuff to see there's going to be some regulation, and we are going to then perhaps curate the online world based on the European regulations, because Americans were not going to do anything about how the platforms are going to be regulated. And to dig deeper into now those definitions, this really, really helps. I'd love to ask you a few questions, but I'll answer the question there as well. But now, especially in the time we are, I think some of the things which we've always said, oh, Article 17 should not be looking into, I think a lot of it is also up for discussion in how the world understands many of these things. Definitions are changing. Everybody's defining their own. Free speech for me, not for thee. Anti-Semitism means whatever it means, etc. So at this point in time, to have something like this, asking the tougher questions, I'm very, very glad that you're doing it. Also a big fan of Vanderbilt and Jacob and everybody else, all the great work you are doing. To answer your question, I think I'm generally tempted to use Occam's razor and give simple explanations for everything, but free speech is complicated. One problem, because there has been a big rise of hate speech amplified by the platforms, which has resulted in real world harm. And there has been increased demands of censorship even before what the crisis we are currently talking about. And that's not just from states and the practitioners of digital authoritarianism, which if Richard was here would have been able to talk about it, but also cancel culture warriors, who we may think were perhaps on one side of the political spectrum or not, has been everywhere. And what ends up happening is that it's always directed towards the speaker. Who is the speaker? That's the person, that's the object. And when I talk about real world harm, I do want to say the hypocrisy of American platforms as First Amendment defenders has been something people like us who worked on these issues since perhaps 2012, 2014 have been calling out for a long time. They're very happy to talk about the First Amendment rights and how they're going to do a bunch of things, but never ever taken any real serious discussions in other parts of the world also. And India is a tiny country, only with 1.25 billion people. Their largest market in many ways, yet what we saw first was to completely dismiss any kind of objection coming out from the larger civil society or people who were minorities and were being targeted by organized hate speech funded by cheerleaders of parties in power. Never taken seriously, never understood, and it was always like, we are absolutists, this is not going to work. And fear for us was, if you don't address this, this is going to become an excuse to then to have high-handed regulation coming from the government saying, oh, we're only trying to protect you, because that's all what governments do, and use that as an excuse to create much more of a censorship framework. Because these are people who are working on the ground, we were mostly right. And then the platforms went into the other direction. The other direction is they're now absolutely complicit in censoring everything which comes up, which the government tells them to take it down, because they say, oh, we're just going to lose our safe harbor immunity, which is Section 230 of Communication Decency Act in the US, a different section in India. So that is the status now. They're so complicit that one demand from the government and everything just disappears. And that's mostly the American platforms. And I'm not going to talk about Indian, because Indian platforms were always groveling and ready to actually crawl when asked to bend. So that problem already existed. But that's where the American platforms are. In terms of hate speech per se, we don't yet have legislation, but we already have some sections in our penal code which actually do talk about promotion of enmity towards another community, religion. And you very eloquently talk about Article 17 and why history is important and how you understand. Even when you were analyzing various discussions, you talk about the Armenian genocide. I think communal riots is a big part of where we are. I am Indian. My favorite thing to say, and I absolutely believe in, is the British Empire created all our problems and left us with it, and that's true for many regions in the world.
Ditto.
So, and we're still paying the price for it. But even then, I'm going to say is like India gets its freedom in 1947, an important decade in a lot of ways, and there is a history of communal riots. So there is some reason always given by legislatures and people who legislated why a law exists on our books when it does. But this has just moved a little bit differently. I think we've seen actual hate speech against communities, especially in India, against the Muslim community, pretty much become a part of the political narrative. And yes, it has added another medium, which is online medium, and it's only added and amplified. It hasn't taken away from the traditional rallies, assemblies, prints. Now we have social media. When in India, we see election cycles always amplify these incidents of hate speech. And because it is also used as a tool of political mobilization. And that political mobilization relies on building a communal narrative of hatred. The instances of hate speech against minorities jumped 74% last year in India when we went to elections in 2024. And this is a research group based out of DC, which is called India Hate Lab. We cannot run such things in India. There used to be a hate speech tracker by a newspaper. The editor was kicked out. He lives in the US now because you can't do such things in India. But that group documented 1,165 instances that time and cited the current prime minister and his rallies, the current party leaders as they talked about many of these things. This was to talk about infiltrators, people who have too many children, and the rhetoric was not dog whistling. It was so clearly talking about vote jihad. If you nowadays anything a problem, you just add a suffix jihad and then you know what you're doing there. And that's constantly being used to say there is a certain community and we need to unite against that community. And cricket, because we think baseball is too slow, but cricket, which is a national religion in India, it's also being used to say, oh, if the opposition comes into power, they are going to decide the Indian cricket team's composition based on the religion, and the people with more children will have that. That's the kind of thing is normalized in India. And when a riot actually happens, which is communal harm happening, that's the police doesn't do much, or it's celebrated uh, in terms of where we are. And there is so when I said there's no specific hate speech law, the upper house of the parliament did come up with a kind of a template and then asked the states to enact some. And we got Karnataka to do a hate speech bill this time, which is now trying to say that they're going to prevent hate speech. And the only good thing to come out of that law was basically that they're going to invest in education of people and trying to say you should be able to recognize what's going on, everything police cannot do, so you need to be educated about it, and people should be able to address these issues. That's the only relevant clause. Otherwise, it is mostly about, again, very, very nebulous terms, which you really can't figure out what kind of an emotional harm somebody would do or somebody would have. And there is a very interesting exceptions to the hate speech as defined in this large state where India's Silicon Valley sits, Bangalore. It says there is going to be exception for bona fide artistic creativity, academic or scientific inquiry, fair and accurate reporting. And I'm telling you, most of the mainstream media in India is now captured by the political party. So you can imagine what fair and accurate reporting means here. And then it is also, if certain sects of a religion are being promoted, that's an exception. So if in a communal country you're going to say we are just going to use that, when we know that religious basis is how you actually start hate speech, you begin to see what the government does when it tries to say, oh, we are just addressing hate speech, etc. So as I said, even we don't need new laws. We have enough of them, but there's selective accountability and weak enforcement. And it's also a lot about power structures. It's the thing which you were talking about, Arya, and Victor was talking about. I think when large institutions, especially in this country or in larger regions like Europe, when they make certain decisions, this is not so much about a judgment, it's not about a case, it's about universities succumbing, law firms just saying, okay, this is what we're going to get a settlement in, then the details don't matter as much as the optics matter, because everyone else around the world watches and says, well, they have no moral authority anymore to ever dictate us, which had already been started to be rejected by a lot of people. But what I'm talking about was that collective accountability of various nations to keep people in check. Now we've lost it all. From here, from everywhere else, people watch, people see, and then they're like, okay, if it's fine for these other democracies or the Western democracies who are anyway playing these double games, why is it not good for us? And then add the great thing these days of AI in the mixture. I think it's really important to see because the tools are so much at everybody's disposal. The conspiracy theories of, in India at least, we've seen that population jihad, rail jihad, love jihad. Rail jihad, oh, are Muslims getting more railway tickets somehow? Love jihad, oh, a Muslim guy want to get married to a Hindu girl, that must be love jihad. But all that is widely reinforced through AI generated imagery. And that frames a particular person in a particular way. And I will say that happens, the stereotype part of us stereotyping people is a common thing. We all have seen it, have done it. And then the stylized animated aesthetics, I don't know if you guys are a big fan, but I was a big fan of Studio Ghibli, or Ghibli as you call it. But that all those imagery made violent, hateful content appear more palatable to people. And that makes it humorous and it broadens to younger audiences. And that part is really creating much more problems there. And the other stuff which I do want to at least say is that we're in the US right now, in terms of just what may not be legally termed as hate speech, but there's an there's always an anti-some community hate on platform, which gets amplified and now is turning into real harm. So as much as I don't want more legislation or I want it to be framed in a certain way, I also think that we can't turn a complete blind eye to what gets discussed, amplified, and then normalized, how it translates into real harm for people.
I definitely have a question to follow up, but I saw a hand from the audience, so I'd like to.
Yeah, thank you very much for an interesting presentation. I was wondering, obviously you're talking about Muslims. Is there any other group in India which is targeted by the current regime?
Yes, Christians would be targeted, minority communities would be targeted. Anyone who will, women especially, if they have a political opinion, an online harassment campaign that would run. Any political journalists, most of the people who've been targeted have now moved to YouTube channels because they won't be allowed to speak on mainstream media. So that would be there. I did target that as India has a second largest population of Muslims in the world, but that has become a major thing about how it is amplified. But there are definitely other communities who will be targeted and then demonized. We still have a caste system, very perverse. We've also brought it here, and that will happen all the time. People from lower castes, as if their life was not already difficult, but the privilege would do that as well.
So just, oh, yes, Ian.
Well, so a question about whether the Indian law distinguishes between hate speech and incitement to violence. And I'm interested also in the tracker that you mentioned in Washington, D.C., I think. Does that distinguish between hate speech incidents and incitement to violence?
That's a good question. So there is it does say, like, because it is a penal provision, it does say it's any promotion of enmity, hatred, etc. So it is pretty wide. So incitement for violence, there's another one. We have 295 also. And so this offense particularly, which has been used in these manners, it involves even using words or signs or even visible representations. It may not be an actual incitement to violence, but if there is one, that also is another section which it will be recognized in.
And is the incitement to violence provision of the penal code prosecuted even-handedly?
No, that's a great question. Yes, if you are privileged, not even handedly, but no. The answer is no, exactly, because it is the enforcement is that's why picky, and it depends on the power structures very much so. Who's making a complaint, who's in power, what was going to happen. A lot of times there are complaints that are made, but which is the first information report, but they won't be prosecuted. And the state's infrastructure is such that, like, we have another pre-trial kind of a thing, which is called a UAPA, in which Umar Khalid has been under. There's only 2% prosecution rate, 97 point whatever few percent people are always acquitted, but the trial doesn't start for 5 years. So what are you going to do for that? But yeah, so it's not. And that's why you're raising the right question. That's why when statewide legislation come, our first question is, why do we need this additional stuff? But the ostensible reason is, look at social media. We need to take these things down. And there needs to be a narrative story. But the story is basically we are trying to protect people. But most of the censorship, because we do digital rights, so we do a tracker of how many websites are taken down, how many accounts are taken down, which are the handles which will be taken down. And there's a clear bias there, which is evident that if the government doesn't agree with what you're saying, this is going down. If we are going to have skirmishes on the India-China border, we are going to shut down applications and websites. If we have a problem with Pakistan, we're going to shut down websites. We're going to shut down applications. And all the government needs to do is just say, this is what we would not like to be there. So more legislation only means different tools in their hand to have a toolkit to say, shut this down, shut this down, shut this down, and to increase censorship.
building on that a little bit, Natalie really went into a lot of the scholarship, and I thought that was a wonderful section of the book. And you talked specifically about certain examples, such as, and this is again dealing with incitement, talking about what happened in Rwanda with Radio Mille Couvin, and then also the issues with hate speech relating to Myanmar and how that helped fuel the genocide there. So those were instances where there was clear incitement, and in those instances there seems to be clear lines where there should be some sort of intervention by courts and platforms. So I wanted to kind of sort of parse that out as one category, but then there's this other bucket that you talk about where the scholarship points to harms from hate speech, which Misha was just talking about, that are more long-term. They're resulting in embedded forms of discrimination and political polarization, particularly also what we're seeing in the United States. And those may require different strategies, such as counter speech, which I know Natalie's worked on, media literacy programs. So like, how do we parse out like what's in the domain of the courts, what's in the domain of the platforms to regulate, and how do we as a society start to counter some of these issues? That's kind of a big question, but anybody want to comment on
Yeah.
that? Natalie?
Okay, I can start the discussion.
Okay.
I mean, it's a very difficult question. And there is a series of cases before the European Court of Human Rights. It's the chapter I have on the low threshold, like paradigm, where even Article 17 that we had discussed before was used in a case, Norwood versus the United Kingdom, where a person lifted a banner and he hung it out, on his window, and it said, "Islam out of Britain, protect the British people." And of course, that's disgusting speech, but the use of Article 17 alludes to all the problems that we had mentioned before. And then the case of Ferrer versus Belgium, where a politician of the Belgian National Front was saying things like, protect Belgium from Islam the Conqueror. And then you have the Swedish case of Valand, whereby a group of people were giving out leaflets linking homosexuality to the rise of HIV and pedophilia. Again, absolutely disgusting speech. And another very interesting case, an Icelandic case, whereby somebody had commented under a news article about education or a support system within a school for pupils belonging to the LGBTQ plus community, and he was saying things like, "This is disgusting," and the classic awful speech that we see. So that would be within that framework, whereby I don't feel that can really sit well within a judicial kind of ambit. Particularly, I mean, the European Court of Human Rights for us is the regional court for human rights. It's a very important body. There's a judge from every Council of Europe state there. I mean, it's not just any old court. It is the human rights court of our region. So I really don't feel that these kind of cases belong there. Not because I don't find that speech absolutely awful, but because I also worry about all the scholarship which shows the counterproductive effects that legislating and criminalizing speech may have. So that would be one thing that I would say, and I'll come to how we distinguish. But when we do silence people, when we are like using criminal law to shut people down, look at Tommy Robinson, for example. Let's move out of the legislative and judicial framework. But Tommy Robinson from the UK, I mean, appalling speech, appalling, for me, that's appalling. And he was off Twitter, and then he came back onto X, and his coming back, it was his return, that was boosted, and was because he had been banned. So this banning and prohibition, we can just go back to the Weimar Republic in Germany and all the different laws that existed, and with the prohibition of certain newspapers, etc., and how they were later weaponized by, Hitler and the Nazi Party could still rise within a republic which had all a series of those laws. And I mean, a great scholar and dear friend who writes extensively about this Weimar fallacy, Eric Hines, explains this in such great detail. And then all these laws were weaponized by. So I mean, I do find it very worrying when these low threshold cases are taken before courts. And I mean, if we turn to countries like Hungary, we have this, I'm saying we because it's Europe, but it's still a sovereign country, but yeah, could be. But Hungary, for example, has a law that prohibits, it's framed under the ambit of children's rights, but it's actually a law that hates the LGBTQ community. So, I mean, but that's a hate speech legislation that's used to silence people. So you never know whose hands this can end up in. So that would be the first thing. And the second thing that I would say is, how do we distinguish and how do we, I think I'm going to go back to Hines again, and in his wonderful book about on hate speech and democratic citizenship. He basically distinguishes between long-standing and prosperous democracies and saying, within a long-standing and prosperous democracy, which I would hope the Council of Europe states, or at least the majority of them, are. Let's not forget that Russia is no longer, or for the moment, a member of the Council of Europe following the invasion of Ukraine. So he discusses, it depends on what kind of democracy are we talking about? Are we talking about a democracy that's long-standing and that can deal with this kind of speech and that has the infrastructure and whatever else? So it depends on these different factors. So I think a combination between identifying, the level of democracy, the context. So are we talking about a pre-genocidal context? Were we talking, the situation in Rwanda, for example, and how the radio was used? You can't compare that to if a radio is used in I wouldn't give my country as an example, unfortunately, but France or Romania. It's very different. So there's so many factors, but it's so complicated. And then you can turn around and say, okay, let's look at the Rabat plan of action that we've discussed so many times, and the 6-part criteria. But at the end of the day, I mean, how do you do that? And how does that happen? But it is very good. That's why I'm a much I after studying hate speech for very many years, definitely would support the approach of the First Amendment. And for me, that is the approach that gives space to speech and to awful speech, because I think it's very important to underline something, that freedom of expression is, again, I'm going to refer to Eric, but he's had so many good things lately, good, new publications, but the most human right, it is a fundamental right that we have. But at the same time, freedom of expression is so important because it is the antidote to all these horrifying phenomena that we see. So I find, more speech to be very important to deal with racism, to deal with homophobia, to deal with transphobia, anti-Semitism, Islamophobia. The answer is more speech. But when we do come to the incitement to violence, then yes, that is a very different situation. And I think that I would never recommend anyone in Europe or the European Court of Human Rights or any of my, apart from a couple of friends of mine in Europe, to look at the First Amendment as our way forward, because I know that would never happen. So I'm very realistic in the book. I'm not coming and saying, oh, you know what, we should be adopting the First Amendment, because that will never happen. But we can kind of come in a sort of middle ground. We can look at international human rights law. I'm not 100% a huge fan of the ICCPR and the Rabat plan of action. I do think there is space for a government which doesn't have the best intentions to abuse that, but we need to find a kind of middle ground. So, and in terms of the other very important point that you mentioned of the scholarship, one of the worrying things for me in the cases is that we have all this wonderful scholarship, from social studies. We have, and from different sides of the coin. So if you look at Alexander Tsessis, for example, at Florida State, and his extensive research, essentially he argues how hate speech can create destructive messages, which can create long-term kind of difficulties for communities and etc. And then we have others like Hines, who has argued that we have to be very careful when we say that there's a harm in hate speech and the impact. But the court is coming and legislating and not deciphering on cases and allowing for the imposition of criminal penalties on offensive speech without even looking at this research. If anything's going to come out of my book, I want it to be this. The court, which is also made up of a lot of academics, actually, has to be looking a lot of this wonderful research, which is kind of looks at the impact. So if the court just comes and says, "Oh, there's a hate speech case. The country has the margin of appreciation, and they know best what's going to harm their community, and this is not, this is prohibited speech. This is what happens most often." But it's got at its feet a plethora of research that it could look at. And if there's one thing, I think it would be that the court engages more with, because it does sometimes engage with research. I found it doing it a couple of very, very, very briefly. But I wish it would do that more and I think that if the court started to do that, that things could change. I mean, there are dissenting opinions. If you read dissenting opinions on hate speech cases, there's a great former judge, a Hungarian former judge, Andras Sayo, who is also an academic and
a friend of some of us.
all right, okay. I mean, his dissenting opinions, which I cite extensively in the book, are exactly what the court should be doing. So, yeah.
Natalie, I have a question.
Yeah.
What do you think the arguments you are making, the implication for content moderation, how does that interact what the European Code of Human Rights comes, and then how does it interact with those policies?
Yeah, so that's a very big question and a very important one. I mean, on the one hand, we see the European Court of Sorry, the sun is right in my eyes, and I'm getting sorry. The European Court of Human Rights is being cited in things like the Meta's Oversight Board, its judgments. So we're seeing that happening. But we're also seeing, so the funny thing in Europe is that in the EU, which is a different thing to the Council of Europe, we have the Charter of Fundamental Rights of the European Union, which says that, there's a very clear link and we adhere to the European Convention on Human Rights. But the EU as a region has not acceded to the European Convention on Human Rights, but it's definitely inspired and supports the European Convention. So there is also an impact on court cases on the EU, and we just have to take a look at the Digital Services Act. The DSA says that companies should remove illegal hate speech. It doesn't tell us what that is, illegal hate speech, without undue delay. It doesn't say what that delay is. And the inspiration is things like the kind of threshold developed on this. So I think even if I can't directly say that, this is cited in this policy, or, it's because of the European Court of Human Rights, I feel that since that regional court is setting such a low standard, and since we have cases, for example, the Sanchez case, whereby the French politician was held criminally accountable for a comment made on his social media without removing it. The case of Delphi versus Estonia, where a news company was held responsible for comments made under a news article it had published. So it's kind of setting the scene of a very, very low threshold of what can be moderated, again, without any consideration of other methodologies. So particularly counter speech, because on an EU level, we have this code of conduct on illegal hate speech online, an appalling document, really. But there is one nice thing about it. Now we have this code of conduct plus. There is one nice thing about it. It does talk about counter speech. And I think that's something we're not having a proper discussion on. Kind of integrating these kind of tools. So to answer your question, I feel that it is like this cloud affecting different things going on in Europe, and on a commission level, they know that that's the kind of standard that's acceptable at the European, even though they're not obliged to follow by default. I mean, it is part of the charter of the EU, the European Convention. So if the court is setting that kind of threshold, then I don't think we can really kind of get away from it. So it does have an obligation, and I don't see why the court itself hasn't realized it, to be honest.
I'd like to extend this conversation a little bit to online behaviors that are hateful behaviors. And by that, I mean bot activity and things like troll storms. And I don't know, Mishi, if you've been dealing with some of these issues in your work. This came to our attention because we have a case in our database, and it's called Dumps and Viata. And in that case, it was an African-American university student who was targeted by troll storms instigated by the neo-Nazi site, the Daily Stormer. And in that case, the court did not really think of it as hate speech. They looked at the online harassment and the great emotional distress that it led to, and to the physical threats that she found on campus. So the court looked at this as sort of racial and gender harassment that impacted her ability to safely engage with her university studies. And they ultimately found evidence of intentional infliction of emotional distress that impacted her right to enjoy public accommodation. So it looked as if the court sort of sidestepped the hate speech issues and used other tools, other legal tools, to address these issues. And I want to get a sense of what are you seeing in your work is to how do we address these sort of behavioral problems?
I do want to say that because in India this happens quite a lot, and I'll give my own example actually. And that's the reason why at least the new proposed legislation, whether it's Karnataka or otherwise, they are trying to say not just a clear intention to harm or inciting harm, but they're also saying, or if you just want to promote or propagate hatred against somebody's race or religion, and using any means of communication. And that's bringing two things together, because we know that it's not just incitement to harm which is happening, but it's the other stuff which also happens. And at least the desire is, oh, this is so much, so we must do something about it. And it's not just that violence which is going to come out of it. You asked about an example. My brother is a lawyer for Wikipedia. And Wikipedia was sued last year in India because there is a news agency. This is a private lawsuit which is brought in a federal court. There's a news agency, and there's a Wikipedia article. If anyone knows how Wikipedia works, these are volunteers. They get together. There is never a primary thing in a Wikipedia page. It's always citing other secondary sources. So whoever were the editors, there was a Wikipedia page. They cited 2 investigations by different magazines, and which had stated a few things about this news agency, that they have a bent towards the ruling party or various other things. The agency doesn't like it. They file a defamation lawsuit, but they file it against and make Wikipedia a party. Now, the entire discussion in Wikipedia in courts is, this is an American company. It's not a company, it's a nonprofit foundation. These are volunteers. But nobody wants to get into details because details are complicated. And then you have to really apply your mind and law to do it. Why I'm telling you this story is that, and I do this work, I've been doing it for a long time. I actually started with Wikipedia and Creative Commons and open source. So some journalists call me up and ask, have you seen this lawsuit? Are you planning to intervene? Are you going to do this? So I talked to her. I told her, here is the statement we've issued. We are now looking into it, what we can do. There is another Wikipedia page which just is tracking the case, that such a case is happening. That case was challenged. My brother is now a party as an actual A4 person in person, there's going to be some summons which are going to be issued. There's going to be a criminal case against him. He's only a lawyer who's appearing, who's working for them, and there are other lawyers also. And once this thing comes out in the newspaper, or whatever she publishes, she calls me 2 hours later. She says, "Have you seen Twitter?" And I'm like, "No, I haven't. I've been at work." And she says, "Is Wikipedia's lawyer your brother?" I said, "Yeah." And she's like, and I'm like, "So?" And she said, "They're making a big deal out of it. They are saying you are being paid by Wikipedia to make a statement or something else." And I'm like, "I have a surprise for you, that two siblings can have similar views on free speech and expression and be in favor of them. And I've done this for 25 years now." So, but obviously she says, "Can I say this put it on the article?" I said, "Do you want to make it a headline? Go ahead and knock yourself out. I don't care." But I go afterwards, once I'm done with work, and obviously there's time difference. I was in the US. I cannot tell you the amount of harassment and the number of people who were now beginning to look into my entire work, who had supported me. Of course, George Soros was supporting everybody that time. Everybody is always and then the Twitter storm started. Then you see the same message which propagates from every handle, and it's not one handle. You can't do the blocking. You can continue to do it. And I spent 2.5 hours, and I'm like, this is not going to stop. Then they go on my family. Then they figure out where my parents live, who live in India. Then they figure out who other people are. So, and I have no idea. And then there's a lot of other stuff. As a woman, I'm pretty used to most Indian trolls telling me that I should be raped and then giving me vivid explanation of what they will do to my body, which is okay. I'm used to this. But when somebody tells you this about your family, it hits differently, because they did not sign up for all this. And I had to shut that thing down. Now, in SFLC runs a helpline of, we take these complaints, we actually go to police, we make a complaint, we go to platforms, we shut these things down. And I was like, okay, this is what I run for other people. We should be doing it for ourselves. But I also knew this was relentless. I'm not going to go anywhere. I shut my Twitter account down. I lost that platform. I'm not very popular, but from 18, 20,000 people to 0 takes a little time, and I use it only for work. But that happens quite a lot. But now I'm going to tell you is that when you were saying about going to the police, now what is it that I am complaining about? There is a problem there, because if I cite the hate speech laws, which they are now doing, then I'm also now making, what is the argument actually am I making? There is no incitement, but there is definitely hatred. The problem is that at least the law says if they are trying to do something because of my sex, I can still complain. But is it hate speech? I think it is harassment. It's not hate speech. But as I said earlier, laws these days will define anything as whatever. Hate speech law in Karnataka right now defines it as something where I can book under. But if we were to go that route, then there is no end to it. And that's why I will still come back. And I am in a much different jurisdiction than yours. But I still think that the important part, despite all the problems we are having, is to aspire to the First Amendment norm. What you did in 1970s, 80s, I think that is still the norm, because we have regressed rather than progressed anywhere. And that's the only way, when we come with counter speech or other speech, that's the only way we do believe in it for everybody, and we have that right to offend, then we can move forward. Because otherwise, there are enough clever lawyers everywhere, and they will be able to weave in things. And if we are going to do selective enforcement, we're going to still have that issue, which is why I constantly grapple with this, and then worry about that what direction will we go in.
Thank you so much. We are at time. So I would just ask if there's any final comments from the panel. Aria, do you have anything you'd like to? Well, I'd like to thank you all for being here. It's just been a fascinating discussion. I really, really appreciate your time. And thanks again to our kind hosts.